Thanks very much, Kate. For those of you who are staying with us, I'll introduce myself. My name is Andrew Brown. I'm a barrister at Radcliffe Chambers, and I'm joining you from the basement of Radcliffe Chambers this morning, affectionately known to some of us as the Gulag. And joining me via virtual link is my esteemed colleague, Tina Kyriakides. Good morning, Tina.
Good morning, everyone.
So we'll be talking about the new restructuring tool brought in the last few months and the recent case of Virgin Airways. But before we go any further, I just thought I'd wish everyone a happy Thanksgiving out there. I am American. I am required by law to do so. So happy Thanksgiving to all of you. Now, going to what we're actually here for, Tina, what exactly is this new restructuring tool and where can we find it?
Well, it's really a mechanism to enable a company to reorganise its liabilities when it is, or it envisages that soon it will be in financial distress, as it does by way of compromise or arrangement with its creditors. And it's found in Part 26A of the Companies Act. Now, let me ask you, Andrew, do you think it's going to be a useful tool? I mean, what other statutory alternatives are there, and why would you use this new tool rather than those statutory alternatives?
That's an interesting question. That's a great question. I should say, by way of background, everyone, that Tina and I have decided this morning to have a conversation about this topic rather than just present a boring paper on this matter. So Tina has asked me a great question, the statutory alternatives to the restructuring tool. Everyone who's listening will know these and probably will have dealt with at least some of these. The two main alternatives are, of course, schemes of arrangement and CVAs, both of which bring certain disadvantages to them that you might not find in the restructuring tool. Those of us who have done CVAs know that they can't bind secured creditors, for instance, without the secured creditor's consent. And in relation to schemes, which I think we're going to end up discussing a little bit later, there is no ability to do the cross-class cram down, which is really the hallmark of this new restructuring tool, what I like to affectionately call the CCCD. And generally speaking, schemes, I think they're relatively limited because they largely deal with large companies. You hear about them, the really big things deal with them. Whereas CVAs, I think many of us have a lot more experience with CVAs. They can be used for a lot of SMEs as well. But Tina, in regards to this new restructuring tool, do you think this is going to follow schemes of arrangement? Is it only going to be available for big companies like Virgin Airways, or might we see it in SMEs as well?
Well, I certainly think it's going to be used by the larger companies, and maybe companies that previously had used schemes will use the new restructuring plan, obviously because of the cross-class cram down, which, as you say, we're going to discuss later. Interestingly, the Insolvency Service did an impact study really earlier in this year, and it didn't actually believe that it was going to be used very much by SMEs. I have to say that actually I'm not of that view at all. And I think because it's such a flexible tool, SMEs will start to realise really how advantageous it can be. And I think it will be used more and more by SMEs, and I think it actually should be used more by SMEs. And I think there's certainly distinct advantages for SMEs in using the new plan. So, for example, it's got the ability to include all creditors, and that's, really, as you've said, a real advantage over CVAs, where secured creditors are excluded unless they consent. So you've got really a wrong balance of power there. So secured creditors can get whatever terms they want if they're to be included. If they're excluded, then obviously there's the real danger that the CVA may later on be defeated. So these plans may put companies in a better negotiating position with such secured creditors, because you could just say, well, if you don't go ahead with the plan, then I'm sorry, we're going to have to go into administration or whatever. It's got also a real advantage as far as preferential creditors, and obviously their priority is preserved with CVAs. But you could see now HMRC is to become again a preferential creditor. You might then have negotiations with HMRC before the plan and say, well, will you agree in effect to be paid by instalments? So they're not going to be any worse off. And that might be quite attractive to HMRC. So that also might assist, if you get their consent, in getting a monitoring going, because then it might show more that the company is likely to survive. And also, there's no real reason why these plans should be really, really costly, and there's a number of reasons. First of all, these plans with SMEs are likely to be much simpler than for larger companies. They're really unlikely to have the real complications and complexities that you get with larger companies. In that respect, you actually might be very interested to learn that actually R3 has got a working party concerning these plans. That's being co-chaired by Alison Goldthorpe of Norton Rose Fulbright. I'm sure a lot of you actually know her. But one of the things they're looking at is actually producing potentially a precedent that obviously could be used and adapted, particularly with SMEs really in mind. Also with SMEs, there's going to be very likely much fewer classes of creditors, so you're likely just to have secured, suppressed, and unsecured. And unlike CDAs, well, you don't have to appoint a nominee or a supervisor, so you may save costs on that. Or it may be part of the structure of your plan, and you may decide to have somebody to monitor it. But unfortunately, I think SMEs are beginning to take an interest, but I'm not aware of any SME that's actually gone ahead with the plan. So at the moment, we've only got 2 large companies who have proceeded. We've got obviously the Virgin case, that's the main case, and we've got Pizza Express, which really has followed that, but only at the convening hearing. So I think maybe, Andrew, it's really time that we turn to the Virgin case and that we also turn to Part 26A itself. What maybe I'll do first of all is just really summarise the background of the Virgin case. So with Virgin, obviously it was suffering a liquidity crisis as a result of this pandemic, unsurprisingly. And so what the directors considered was the method was actually an injection of funds, really by an injection of new funds. They thought it would run out of cash by the week commencing the 5th of October. And so therefore they thought it was just inevitable then that the company would enter into administration by mid-September. So really the restructuring plan proposed was part of a recapitalisation so that the airline could continue as a going concern. And the evidence was that under the plan, really unsecured creditors would be better off than if the company went into administration.
Well, that's quite interesting background, but I wonder if we can just narrow down a few of the issues as I understand them in Virgin, and perhaps you can bring this out. I understand that you essentially structure creditors in classes in the restructuring tool. Can you tell me how the creditors were structured in Virgin? How are they addressed?
Yeah, I mean, obviously the legal position on that we're going to discuss later on. But in Virgin, there were essentially 4 categories of creditors. So there were lenders under a secured credit facility. There were the lessors of 24 aircraft, connected parties who were creditors under various licensed joint venture and service agreements. And there were certain unsecured trade creditors, and they were called the trade pan creditors. So under the plan, all of the rights of these creditors were to be varied. However, in relation to the first 3 classes of creditors, actually they had all, 100% of them had actually agreed to the terms of the restructuring plan, but for various logistical reasons, the trade creditors had not been asked to sign up and agree to the plan beforehand.
That's interesting. I'm just going to jump in because I just want to ask a question about that. So 3 of the classes of creditors had completely agreed to this plan before it even went to the courts. Do they actually, if a creditor class has agreed completely in advance, do they need to be part of the restructuring tool?
Well, that's a very interesting question, Andrew, because that was something that actually Mr. Justice Snowden made in the sanction hearing of that case. And what he really observed was that those 3 classes of creditors really should have entered into a consensual plan rather than being, consensual agreement rather than being part of the restructuring plan. And we're going to talk about that later. But what it was really argued was that the reason why really these 3 classes of creditors were really included within the plan was that if in fact the trade creditors say they voted against the plan, because of the cross-class cram-down provisions, it meant that the plan could then go ahead and be approved. What's interesting is that Snowden said, well, I'm not going to be drawn into that argument for this case, because actually the trade class plan creditors actually did agree to the plan, so it wasn't necessary for him to do so. But he said he's going to leave that open, in effect, for a decision by later court. So really the issue is whether or not, if you've got consensual classes of creditors, whether or not, in effect, those classes are being used for the purposes of manipulating the cross-class cram-down provisions. So to try and get, the court to agree to it, either as a matter of its jurisdiction or its discretion. So that's something that's going to be interesting to watch that space, to see if in the future that problem does come up. Now, interestingly though, actually in Virgin, there were certain creditors who were actually excluded from the plan, and those included creditors where actually bilateral agreements actually had been agreed, and also a significant number of creditors whose debts had not been reduced or deferred. So Andrew, we've got to this position, we've got Virgin. Virgin has produced its plan, it's done all its negotiations and so forth. So perhaps you can help here. So what would Virgin and any other applicant, what would they then have to do to get the plan approved?
Well, thanks. It's always good to be answering the procedural technical questions.
Rather you than me.
Well, thank God for being able to have the internet to look these answers up if I need to. So obviously the answer is, in short, you go to Part 26A of the Companies Act and the practice statement for both schemes and restructuring tools. Now, I'm not going to go in depth on those at the moment. I don't want to drive our entire audience away by doing so. But in essence, if you want to use the restructuring tool and you want the court to sanction any sort of plan, you have to make an application to the court, which involves a two-part process, essentially two different hearings. You have a first hearing, which is called a convening hearing, whose primary purpose is to satisfy the court that class meetings of creditors and or members should be convened. And the second hearing then is to consider whether the plan itself should be approved. So in essence, you almost have a first procedural hearing and a second sanction hearing is really the way to think about it. So if we think about the first hearing, in Virgin Atlantic, what the judge emphasized, and I think this was Trower, wasn't it, emphasized first the importance of giving adequate notice of the various matters to all of the creditors and members who might be affected by this restructuring tool prior to the actual convening hearing, so that if they wanted to challenge it, if they thought that this whole thing was Looney Tunes and it wasn't going to work or they were going to be massively prejudiced, they could show up to that hearing and challenge the plan under one of the sort of tests that need to be met. So in Virgin itself, that meant actually giving appropriate and adequate notice to the trade plan creditors, as you called them. In that case, the court was satisfied that adequate notice had been given. Now, if you actually look at the practice statement, it sets out the various issues which an applicant is required in its evidence or otherwise to draw to the court's attention. Obviously, we have to bring everything to the court's attention. We cannot deal with all of these today, mostly because we've only been given 40 minutes to do this, and I don't have the will or desire to go through them ad nauseum. But we're going to deal with some of the issues of jurisdiction and class composition now. So now, in order for the court's jurisdiction to be engaged, the court must be satisfied that 4 conditions are met initially. And here, since you're my former pupil supervisor, I love to put questions back to you, since you did that to me for so long when you were training me. Perhaps you can tell us what the first 2 conditions are. I'm going to put you to the test, Tina.
Okay. I'll then get back to you. Right, so we've got the first test, the first jurisdictional test, is that the company must be a company, and that's defined as a company liable to be wound up under the Insolvency Act. So if you're a company like Virgin and you're incorporated within this jurisdiction, you clearly satisfy that test. Now, if you're a company and you're incorporated overseas, it's likely the court's going to adopt exactly the same approach as it does in schemes. So really what the court will be looking at is whether or not there's a sufficient connection with this jurisdiction, and also whether the plan is going to be effective in practice. So that's going to be looking at issues of recognition in the relevant foreign jurisdiction. Now, the second test the second jurisdictional hurdle is actually a financial test, and that's whether that the company must have encountered or be likely to encounter financial difficulties that are affecting or may affect its ability to carry on as a going concern. And you may really ask, well, what does that mean? Well, unfortunately, Virgin doesn't supply any answers because the court didn't have to consider the meaning. It was satisfied really that on the basis of the evidence and the explanatory statement, the test was clearly satisfied. But in my view, I mean, just looking at it, just a few points. First of all, the test is clearly an objective test. It's drafted actually in very wide terms. So in my view, the threshold for satisfying it is really quite low. It's clearly not aimed at just insolvent companies, but also at solvent companies, where the figures show that the company is likely to encounter financial difficulties, which may affect its ability to carry on as a going concern. In other words, what it does is to permit the board to take preemptive action before the company actually encounters these financial difficulties. Also, the term likely is probably going to be interpreted in the same way as administration. So the threshold test will be whether or not on balance of probability.
I wonder if I could just dive in really quick here.
Yeah.
Because there's something which sort of troubles me about that test, which is you talk about likely to encounter financial difficulties in the future. In the future is such a broad term. You said that these are kind of vague, broadly worded provisions. Well, what does that mean in the future? Could it be 3 months, 6 months, a year, 2 years? I mean, in Virgin, obviously, it was a few weeks, but what do you think the cutoff limit would be?
I don't know why you always ask me the difficult questions.
Like I said,
it may very well be, to be honest with you, it may just depend on the circumstances of each case. I mean, it may vary according to what financial information the company's got, what the circumstances of the company's trading is. So the court may just have to look at it on each individual case. But as a general broad brush approach, the answer may be that it's when the company reaches such a point, maybe this will be the cut-off point, that it can't reliably be predicted, that it is likely to encounter financial difficulties which will or may affect its trading as a going concern. And so really it's a judgment call. Unfortunately, administration doesn't help us very much because obviously the test is much narrower. You've either got to be insolvent or really you're facing imminent insolvency.
Well, which was the case, I suppose, here in Virgin. But
yeah,
I have another question because I know the questions I'm asking. This is quite a bit of fun this morning. I'm holding you hostage on this video. Is another term which you had in there, which was trading as a going concern. Now that's trading as a going concern. It's obviously not just insolvent or solvent. So what does it mean to be trading as a going concern from statute?
Yeah, again, I mean, the statute doesn't define that, but it may be that it's going to be interpreted in the same way that accountants interpret the term. So it's a question of whether the company will be unable to trade in the foreseeable future. Now, I know that for accounts, I mean, when you're looking at auditors signing off, you're talking about roughly a 12-month period. Whether the court will go as far as that, I just don't know. But it may inform the court, actually, interestingly, as to your previous question, and maybe that will be the maximum limit to which a court will ever go. So, Andrew, I'm going to throw the ball back in your court. So you said there were 4 jurisdictional tests. I've done 2. It's your turn now. So what are the other 2?
Oh, thankfully, I think my 2 are slightly easier to go through. Well, the third test is just to establish that what is actually proposed under the tool is a compromise or an arrangement between the company and its creditors. The court in both Virgin and Pizza Express adopted the same approach, which is used in schemes of arrangement, which is to say that there must be an element of give and take between the company and creditors. It cannot simply be the company taking from the creditors. And I'm just going to jump right into the 4th test before you ask me any dangerous questions, Tina.
Don't worry, I'll have one for this one, I'm sure.
Delightful. So there's a fourth test, obviously, which is what's called the purpose test. And this is really the intention behind the proposal. So the purpose must be to eliminate, and here I'm going to read off my screen so I get the words right, to eliminate, reduce, prevent, or mitigate the effects of the financial difficulties which you were talking about earlier, which are foreseen as coming to the company. Obviously, in Virgin, it was held that the broad language, there's broad language in the statute, and that should be construed expansively. So the threshold is essentially quite low, although the court, as with its other procedures, will be astute. So the court's really going to be looking at this as to whether or not what is being proposed under the scheme is some sort of abuse.
Okay, so let me interrupt you there. So you say about abuse. So what do you think would be improper use? What's the court? What's trying to be avoided here?
Well, that's a mean question because there's not been any case law on this, so I'm having to now postulate here. You know, if I were saying what could be an abuse, how would you be using the tool wrong? If you're trying to, as a company, just gain financial flexibility, maybe, so you're trying to essentially bind creditors or a certain class of creditors in such a fashion that you're just able to move freely and you're not actually facing financial difficulties, or you don't really think you're going to be facing financial difficulties. Or perhaps if you try to single out using the cross-class cram down a particular creditor that you might try to do one over on, or might try to disadvantage in some fashion due to whatever reason. I mean, it might be a somewhat difficult thing to prove unless you're really going through communications between directors and such to know what their actual intention is. So it will be interesting to see what the case law develops on this, but that's kind of what I think as our potentials. Thanks for asking that question on springing on that. That was delightful. So I'm going to move right back into my plan of what we're going to talk about now that I've answered that. Is that we've got to the stage where the court is satisfied that its jurisdiction is engaged and that there is sufficient notice which has been given to those affected by the plan. But what do you think the next important thing the court will have to consider? What is that?
Class meetings and also class composition, I think, is going to be really the next important thing on the agenda. So let's consider first, so what creditors have the right to vote at the meeting? Could maybe you explain that?
Well, thanks, throwing it straight back to me. The thing that I wrote notes down on this point as well. So every creditor whose rights are going to be affected by the plan must be permitted to participate in the meeting, ordered to be summoned by the court. But it won't apply in relation to those class of credits if the court is satisfied on an application made by the company that none of those members or those creditors actually have a genuine interest in the company, or that the members have a genuine interest in the company, or if the creditors don't have a genuine economic interest.
Well, so Andrew, should we just break that down a little bit, because it seems to me there are really two questions that arise from that. So the first one is what does the Act mean when it says a class of creditors? How are they determined? And the second question is that what does it mean that creditors cannot vote if none of the members of that class has a genuine economic interest in the company? So maybe you could actually deal with the first question and I'll deal with the second.
Sure. Well, the first question is easier to answer, thankfully. Although in practice it might be slightly more difficult. So in Virgin, the court essentially didn't have adverse argument on this point. And the judge, Trower, again held that the approach to class composition under schemes of arrangement should essentially apply to the restructuring tool in theory. So in schemes, the court determines whether the legal rights that are going to be released or varied of the creditors are so distinct, essentially, that those creditors need to be treated as separate classes. If their rights are so dissimilar as to make it impossible for those creditors to be able to consult and form a common interest and a common view as to what their common interest might be, then they need to separate those creditors out into multiple classes. And there's been a lot of authority in schemes of arrangement about this. I've written down some notes on my computer here, so I actually sound like I know what I'm doing. Hawk Insurance Limited, and in Hong Kong, Lord Millett did Argos Engineering and Heavy Industries. We're not going to go into those because we don't have time to do so. So therefore, in schemes, in determining the class composition, the court is to focus on the legal rights of the creditors, not their separate commercial or other interests, just their legal rights. So in Virgin, that's exactly what was confirmed, that the rights of those included within a single class can be subject to material differences, provided they are not so dissimilar as to make it impossible for them to consult together with a view to their common interest. You said you're going to deal with the second question, because I'm definitely spinning my tires a bit in the mud at the moment. So perhaps then you can talk about which creditors will not be entitled to vote.
Yeah, so just hold your horses a minute, Andrew. Just before we leave your subject matter, are there actually practical difficulties between the way that a company might seek to approach class compositions in schemes and the way that they might seek to approach it in these new plans? I know that we're going to shortly deal with the issue of cross-class cram down, but don't those provisions really affect how a company might seek to organise its classes?
Yeah, that's a good question. And thanks for bringing it right back to me. Yes. So in schemes, generally speaking, the way you organize your class of creditors, well, I should say by way of background, in a scheme of arrangement, if a single class of creditors rejects the proposed scheme, that's it, the scheme is scuppered. You can't bind the dissenting creditors. So the way you do that, or the way you get around that, is to have as few groups of creditors as possible that are as big as possible, so you can water down any dissenting opinions as much as possible. So there's a bit of manipulation and planning going there. In the restructuring tool, it's actually quite different, and I think we're going to talk about this a little more in depth. But because you have the cross-class cram down, you can have a dissenting group of creditors which are going to get bound by the proposal anyway, if approved by the court. So really what you want to do is you want to have as many potential groups of creditors as possible, so that at least you get one which approves the plan and might bind others. And ideally you have multiple groups which can bind, and maybe you can put the dissatisfied creditors together so they can all get bound quite easily. So there's the possibility that the company might seek to manipulate its class composition in the case of new plans in order to create as many classes as possible, in the hope that at least one would approve the plan. And the judge in Virgin was conscious of this possibility, that there might be some sort of manipulation. And here, me being an American, I get to come back to something which I live with every day, or used to live with every day, and which we saw in the recent American election, which is the issue of gerrymandering, which comes from US election law, where you redefine districts, voting districts, to try to get those people that you want in one district, and you try to spread out the dissenting voters in as many districts as possible, so they can't actually affect the outcome. In schemes of arrangement, they've previously said that the court is going to really look at this to be astute in the attempts to manipulate the class composition. Where different classes of creditors are proposed, the courts may therefore have to be prepared to scrutinize more closely whether the rights of various creditors are so different so as to warrant being placed in separate classes. And perhaps I'm going to drag you back into this because I was speaking for too long and I'm getting tired. Perhaps you can help here, because I know that the English court or the English approach to class composition adopts a legal rights-based approach, but is that enough? Is there another approach which we might adopt in this matter?
Well, forgive me if I get it wrong, because I'm not an American, but as I understand, in Chapter 11, the court will actually examine whether the debtor really has proper reasons for its class compositions, which are independent of any motivation to actually secure the vote of an affected class. And as you rightly said, I mean, this is actually not the current approach of the English court. And I would have thought that actually in England, in the majority of cases, the legal rights-based approach would probably be sufficient. But you can envisage, particularly, there might be a difficulty. So say effectively what a debtor does in the plan is it artificially really separates creditors who otherwise would be in the same class and really creates different rights for those creditors, with a view then to creating different classes of creditors. So it's another form of manipulation. In that sort of situation, it may very well be that just adopting a purely legal rights-based approach will actually not be sufficient. But it may be that the approach, it's going to be quite interesting. It's whether or not the courts will look at that at the convening stage as one of class composition and looking at how they do their classes, or whether or not it will then do it later on and look at it as one of its discretion as to whether or not to sanction the plan. But it'd be very interesting to see if a case like that ever does come up before the courts and really how the courts approach that.
Well, hopefully we get to deal with those cases ourselves. So we know in the Virgin case, the court was satisfied that the class composition was proposed appropriately. But what if an applicant applies to exclude a class of creditors from voting on the plan? Is that something they can do?
So as we've said, we know that a class can be excluded if none of the members of that class has a genuine economic interest in the company.
Hold on, I'm going to jump in. For those of us like myself, can you explain what genuine economic interest might mean?
Well, unfortunately, again, the phrase is actually not defined in the Act. So does it mean an interest that's illusory, that it's not a sham? Does it mean an interest that is material? Does it mean an interest that's tangible, real? So it's very hard to see how the court's going to look at that. Now, it may be that obviously that's going to be a factual determination. Now, that may and that may not require expert valuation evidence. It may be the court may have taken a similar approach to what you would have on outcome statements in administration when you're looking to go into administration, or it may actually require that there is some valuation evidence in order to establish whether the creditors who act, the class of creditors who are thought to be excluded, are genuine out of the money creditors. So if, for example, on a valuation, they would all the assets would be used to be paying off secured creditors, with none left over for the unsecured creditors, then obviously unsecured creditors would be out of the money creditors and they would have no economic interest. An interesting question is what happens if such valuation evidence shows that a class of creditors does have an economic interest in the company, but it is de minimis? Does that mean they can be excluded? So the answer is I don't know. Sometimes if you just look back on authorities in different areas where it's de minimis, the court has effectively ignored that.
Okay, well, there's two other interesting questions I have coming out of that. If someone, if the rights of a certain class of creditors are affected by the plan, but they have no genuine economic interest so that they are excluded from voting, are they actually still bound by the proposal? And second, before you answer that, if they are, what essentially is the compromise or arrangement with them?
Okay, another difficult question to answer.
This is fun.
You could, on the one hand, argue that if they can't vote, then they can't be bound. But I have to say that's not actually my own view, and I just don't think that's right. My own view is I think that they are bound by the plan. Because no doubt what the plan will do is that the plan will affect the rights. It'll seek to change their rights. However, because they've got no economic interest, then you may say, well, why should really their wishes affect any other creditors who actually do have a genuine economic interest? And indeed, if you actually left these creditors outside of the plan, it really exposes the company to action by these creditors. So they're still creditors. So they could still go to court and, for example, issue a winding up petition against the company, and that would effectively then defeat the plan. So, as I say, my own view is they are bound by the plan, and I suppose theoretically, then the plan will affect whatever their legal rights are. So, Andrew, let's go back to you. So the court, I think we've only got 5 minutes left, so we're just going to have to maybe just speed up a little bit. So the court makes an order for a convening order of the relevant classes of creditors. What happens next? And as I say, I think we're going to have to speed up on this.
Okay, well, we'll happily gallop through this. So after the convening meeting, the company has to send out the explanatory statement to all of the classes of creditors so they know what they're voting on properly. In schemes of arrangement, these are usually extremely long, and it's one of the reasons people think SMEs will not get involved in these matters. Helpfully, the practice statement in regards to the restructuring tool says that the explanatory statement just has to fit the circumstances. So if you're a smaller company that wants to use this tool, you don't need a massive document to go to creditors. It can fit the type of proposal it's actually going to be. Then the meetings will be held, and then the applicant, essentially after the vote of the creditors, will go back to court to sanction the plan.
So Andrew, so you say the meetings are held, and we're going back to the court for sanction. What happens if one class of creditor actually doesn't approve the plan?
This is a delightfully scripted question that I know the answer to, and I can answer quickly. This is where the cross-class cram-down comes in. So as long as you have, well, essentially if one group of creditors dissents, it doesn't scupper the whole deal. If 75% in value of a different class does approve the plan, then all of the creditors can be bound by it. So dissenting creditors can be bound, even if their entire group dissents to the plan. That only will happen in certain circumstances, provided that none of the members of the dissenting class would be any worse off than they otherwise would be in the relevant alternative, so liquidation, administration, or whatever. If a dissenting creditor does not challenge the court, or does challenge, the court will have to consider what the relevant alternative is and what the position would be. Now, we might have to have some sort of expert evidence to determine what would happen. So an obvious example would be a company with assets would have gone into liquidation and the plan deprives a secured creditor of its security. That would obviously be putting the secured creditor in a worse position than it otherwise would be. However, if a position where payment dates to a secured creditor were extended with interest in the interim, the secured creditor would have a protected position, so they would be fine. But what other matters, to try to gallop through this again, what other matters do you think will be considered by the court at this final stage, Tina?
Well, really, as shown really by the Virgin case, really the court's adopted the same approach that it uses in schemes. So really the court will, first of all, if there are any challenges to its jurisdiction and class composition, although if somebody hasn't challenged that at the convening hearing, the court's going to require a good reason as to why they didn't do so. It will also consider whether the classes of plan creditors have been fairly represented at their meetings. So in Virgin, there'd been 100% turnout of the classes of creditors who had previously approved the plan and a really high turnout for the trade plan creditors. Not been suggested that by anyone that any of the voting had been done for any collateral motive or that they'd had any special interest different from the other members of that class. Also, in considering fair representation, the court adopted the Part 26 jurisdiction that in order for the court to have faith in the majority vote as a reflection of the commercial vote of creditors, they had to be properly consulted. Just to sort of say, there are two other tests as well. There's the test of the intelligent, reasonable man, and whether they're blocks or defects. It's just that we've got 1 minute, and I think we're going to have to tell you to go back by looking at the chat. If you click the link to go back to the interview between Adam Deacock and Mark Mallon.
Yes.
But on behalf of us both, thank you, all of you, very much for attending. And we're very sorry that the last part had to be hurried a little.
I blame myself for my long-winded answers. Thank you, everyone.